The record. I am Commissioner Kimberly W. Duffley, and with me this afternoon will be Chair Charlotte A. Mitchell and Commissioners Tanola D. Brown Bland, Daniel G. Clodfelter, Floyd B. McKissick, Jr., Jeffrey A. Hughes, and Karen M. Kimmerat. I now call for hearing docket number A-41 sub 22 in the matter of joint amended application of Bald Head Island Transportation Incorporated, Bald Head Island Limited LLC, and Bald Head Island Ferry Transportation LLC for approval of transfer of common carrier certificate to Bald Head Island Ferry Transportation LLC and permission to pledge assets. On July 14, 2022, Bald Head Island Transportation Incorporated, or BHIT, and Bald Head Island Ferry Transportation LLC, BHIFT, and collectively BHIT, the applicants, a wholly owned subsidiary of Pelican Legacy Holdings, LLC, Pelican, managed by Sharpview Capital, LLC, collectively with Pelican Sharpview, filed an application pursuant to North Carolina General Statute 62-111 for approval, 1, to transfer BHIT's common carrier certificate to Bald Head Island Ferry Transportation in order to operate the passenger ferry transportation services to and from Bald Head Island and the tram services on the island, and 2, for Bald Head Island Ferry Transportation or Sharpview to pledge assets and borrow or issue debt pursuant to North Carolina General Statute Sections 62-160 and 62-161, as may be necessary to finance the transaction. Applicants also filed several exhibits and the direct testimony of witnesses Charles or Chad Paul III, Shirley Mayfield, and Lee Roberts. On August 24, 2022, the Commission issued an order scheduling hearing, establishing procedural deadlines, and requiring public notice, or the scheduling order. In the scheduling order, the Commission provided discovery guidelines and set the matter for public witness hearing on Tuesday, November 1st, 2022 at the Brunswick County Courthouse in Bolivia, North Carolina, and for expert witness hearing to begin on Tuesday, January 17th, 2023 in the Commission hearing room in Raleigh, North Carolina. The Commission granted petitions to intervene filed by Bald Head Island Association, the Bald Head Island Club, and the Village of Bald Head Island, which will also be referred to as BBHI or the Village. The participation of public staff is recognized by statute. On November 23, 2022, the public staff filed a motion to extend the time for public staff and the other interveners to file direct testimony and the time for applicants to file their rebuttal testimony. On November 28, 2022, the Commission issued an order granting the motion. On December 14, 2022, the public staff filed the direct joint testimony and exhibits of witnesses Sonia Johnson, Krishna Rajiv, and John Hinton. The Bald Head Island Association filed the direct testimony and exhibits of witness Robert Dumreller, and the Village filed the direct testimony of witness Scott Gardner. On December 21st, 2022, the Commission issued an order holding proceeding in abeyance, which, among other things, stated that the expert witness hearing was continued and would be rescheduled by further order of the Commission. On January 20th, 2023, the Commission issued an order rescheduling hearing and establishing additional procedures, which, among other things, set the expert witness hearing to begin today. On January 24th, 2023, BHIT, BHIFT, and Bald Head Limited LLC, together with BHIT and BHIFT, the amended applicants, filed the amended application pursuant to North Carolina General Statute 62-111, the amended application. In addition to seeking approval to transfer Bald Head Island Transportation's common carrier certificate to Bald Head Island Ferry Transportation for operation of the passenger ferry transportation services to and from Bald Head Island and the tram services on the island as noted in the initial application. The amended application seeks approval to transfer the parking facilities and barge operations to the extent the commission has jurisdiction and authority to regulate them as may be determined on appeal. Amended applicants also filed the amended testimony and exhibits of witnesses Chad Paul, Shirley, Mayfield, and Lee Roberts containing confidential information. On February 3rd, 2023, the village filed a motion to hold proceeding in abeyance and request for expedited ruling on the motion. On February 6, 2023, the commission issued an order requiring responses to the motion to hold the proceeding in abeyance. And on February 8th, 2023, BHIT and BHIL, Sharpview, and the public staff each filed a response or supplemental response to the motion to hold proceeding in abeyance. On February 9th, 2023, the village filed a reply regarding the motion to hold proceeding in abeyance. And on February 13th, 2023, the commission issued an order denying the motion to hold the proceeding in abeyance. On February 20th, 2023, the public staff filed amended and supplemental joint testimony of Sonia Johnson, Krishna Rajiv, and John Hinton containing confidential information. On the same day, the village filed direct testimony of J. Lee Lloyd, Dr. Julius Wright, and Kevin O'Donnell, all containing confidential information, and the supplemental direct testimony of Scott Gardner. On February 23rd, 2023, the village filed a notice of use of affidavit. On February 27th and 28th, 2023, amended applicants filed joint rebuttal testimony and exhibits of Chad Paul and Lee Roberts containing confidential information, and rebuttal testimony of Bion Stewart, and rebuttal testimony and exhibit of John Taylor. On March 1st, 2023, the public staff filed for substitution of witness and adoption of testimony, which was granted on March 3rd, 2023. The presiding commissioner wishes to make clear on the record and modify the March 3rd, 2023 order to grant Michelle Boswell to be substituted as a joint sponsor of the direct joint testimony and exhibit and the amended and supplemental joint testimony and exhibit previously filed on behalf of joint witness Sonia Johnson. On March 1st, 2023, Bald Head Island filed a motion to withdraw. Bald Head Association filed a motion to withdraw testimony and exhibits of Robert Dumheller, which was granted. On March 2nd, 2023, the village filed a motion to substitute witness and adopt testimony, which was granted. On March 6th, 2023, the village filed notice of amendment to testimony, which I think that brings us to today. In compliance with the State Ethics Act, I remind all members of the panel of our duty to avoid conflicts of interest and inquire at this time as to whether any member has a known conflict of interest with respect to the matter before us this afternoon. Okay, please let the record reflect that no conflicts were identified. I will now call for appearance of counsel, beginning with the applicants.
Thank you, Commissioners. My name is Gray Stiers, of the law firm Fox Rothschild, and I represent the applicants Bald Head Island Limited LLC and Bald Head Island Transportation Inc.
Good afternoon. Elizabeth Hedrick, also with Fox Rothschild, representing Bald Head Island Limited and Bald Head Island Transportation.
David Farrell with the law firm of Nexon Pruitt, here representing Bald Head Island Ferry Transportation LLC, Sharpview Capital LLC, and their affiliate entities.
Good afternoon, Dan Higgins, appearing on behalf of the Bald Head Island Club.
Good afternoon, Marcus Trafen of the law firm of Brooks Pierce, appearing on behalf of Village Bald Head Island. With me are my colleagues Craig Schauer, Amanda Hawkins, and our co-counsel Joanne Sanford is in the audience as well.
Good afternoon, Presiding Chair Duffley and Commissioners. William Creech with the public staff, on behalf of the Using and Consuming Public, joined here by Gina Holt, my colleague in the legal division. Thank you.
Well, good afternoon to all of you. So before we begin, I will make this request of council. Chair Charlotte Mitchell has been called to the General Assembly today and will be arriving late for the hearing, and Commissioner McKissick will need to leave a bit early tomorrow. Is there any objection to their reading into the transcript and their viewing the video conference recording for the portions missed? If you have such an objection, please let me know now and I will hear you. Okay, please let the record reflect there were no objections. Do the parties have any preliminary matters that we need to address?
Not that I'm aware of at this time.
Okay, on the record, could you just briefly state how we are going to be dealing with the confidential information today?
I'll do my best. So a number of, a good bit of information has been labeled confidential. The backward-looking historical financial data of Bald Head Island Transportation and Bald Head Island Limited will no longer be considered confidential. And so there may be questions asked of that and answers provided that will not need to be protected by confidentiality in that regard. The asset purchase agreement and information of Sharpview Capital and its affiliates with its investors, investment information, financing. I don't want to speak for Mr. Farrell. That will remain as labeled confidential, attorney's eyes only at this time. We have confidentiality agreement signed by our consultant, John Taylor. But there are some folks in the room that we have not yet signed or are not able to sign the confidentiality attorney's only. And if there are questions asked or answers that need to be given that would require the disclosure of that information, we would ask that the hearing room be cleared of anyone who has not signed or cannot sign those confidentiality agreements. And I've asked my co-counsel or opposing counsel to correct or augment anything that I've said, which is inaccurate or incomplete.
Okay, hearing nothing further. So there is a lot of information identified in this case as confidential. Therefore, we, the commissioners, are going to be dependent upon you, the parties, to identify when or if any witness or counsel or commissioner is heading into confidential information so that we may stop the hearing and move into confidential session. It would also be the commission's preference when we have a witness coming onto the stand, let's identify get out all of the non-confidential information and then try to go into confidential session at the end of the questioning. So,
Madam Chair, if I could speak
Yes.
to that just briefly. And
Sure.
The village, of course, will respect that. The most of the material in the issue is material which has been designated as such by Sharpview. We do, setting aside the procedures, we do have ongoing concerns about the impact of the confidential designations. By our count, 72% of the documents we received from Sharpview have been designated as AEO confidential, meaning that we are not permitted to discuss those documents with our client, nor are we permitted to share those with anyone other than our consultants who have signed the confidentiality agreements. This has significantly impeded our ability to communicate with our client, obviously. And I also believe it's impacted the public's ability to be informed about this proceeding. And I have concerns that it's going to impact the public's ability to monitor this proceeding. That said, I don't know what to do about it. Observing that it's an issue, the confidentiality agreements do afford the parties the opportunity and the ability to challenge designations, and that's something that we are considering, and it may be that we would make a filing at some point, perhaps after the hearing with regards to that, but it's sort of novel situation for me with respect to the extent of these designations. And I did want to recognize the challenges that is imposed on us, but also with respect to the public.
Thank you for that, Mr. Tratham. So it's my understanding, are there any other matters before we move on? It's my understanding that that several parties wish to make a brief opening statement. I'll limit those to 5 minutes apiece. You may begin.
Thank you, Commissioners. On behalf of the applicant, I'd just like to frame the evidence that we will be presenting in our case in this docket hearing. The issue before the Commission, as you well know, is whether the transfer of the Certificate of Common Carrier Authority to Sharpview is justified by the public convenience and necessity. Although the Commission has articulated it in different ways, the standard of whether or not to approve a transfer typically involves a weighing of benefits, costs, and risks. In this case, and there are many, many factors in this case that make it unique, and I did want to respond to Mr. Tratham's comments, but it is unique in so many different ways when you have a significant asset with multiple competing bidders would like to purchase it. But the overriding benefit in this case is the transferring of ownership from, on one hand, a dead man's estate that is liquidating and in fact has already liquidated all of the operational assets other than these transportation assets in Brunswick County, North Carolina. An estate that cannot and will not make major capital investments in these operations and that does not want to own and operate these assets any longer. And that transfer to a North Carolina-based company that is engaged and interested in wanting to own and operate these utility assets, that is investing capital to purchase them, that is purchasing the estate's other assets on the island and on the mainland and will have an interest in the area, that is retaining current management and employees to ensure a smooth transition, and is committed to owning and operating the utility in a way that ensures its continued success. To ensure that the customers, and those are the benefits, and we'll hear more about those during the hearing, but ensure the customers are protected as much as possible from the potential cost and risks of the transaction, Sharpview Capital and its affiliates are willing to accept regulatory conditions on the transfer, which include not filing a rate case to increase rates until it assesses the improvements that may be necessary for the operations at least 1 full year after the closing of the transaction. That's something the current owner has not promised and has no reason to promise. A purchaser that would agree not to raise parking or barge rates by more than the rate of inflation for at least 4 years, regardless of the outcome of the sub 21 appeal until the next rate case. Preserving the availability of existing parking at its current amounts. Limiting cash distributions, maintaining minimum levels of capital, common equity capital, and providing a 10-year plan of capital expenditures. Those are just a few among 28 regulatory conditions that we have voluntarily agreed to and that were attached to the rebuttal testimony. None of those conditions, if you look at the choice between leaving these assets in the hands of the estate versus transferring them to Sharpview, none of those conditions would be binding on the status quo ownership by the estate. And the Commission should consider, we believe, the risks that consider the risk minimized by these conditions against the risk of leaving the ownership in the Mitchell estate. What happens when a vessel needs to be replaced? What happens if a hurricane causes significant uninsured damages to the assets necessary for the operation? What happens if the uncertainty of future ownership makes it impossible to hire or retain qualified employees? The uncertainty and those risks of not approving the acquisition should also be considered. But ultimately, the key issue, and probably what you'll hear most of during the next few days, is the extent that Sharpview will be allowed to earn a rate of return on its full investment in the system. First, let me clarify that the rates base for the ferry and tram assets, which have been operated subject to this commission's jurisdiction authority since 1995, though they will be the same as they have been on the books of BHIL. I mean, that's not an issue on this rate base for the ferry and tram. Now, you will hear testimony from witnesses provided by sponsored by the village that's setting the rate base at the fair market value, the purchase price of the parking and barge assets would constitute an acquisition premium, which should be disallowed. In contrast, you'll also hear our witnesses that will explain that because prior to December 30th, 2022, those assets were never part of the rate base of a regulated utility. And thus there have never been regulated rates for those services that allowed for the recovery of depreciation, property taxes, or a rate of return. In the words of numerous commission decisions, they have never, quote, been dedicated to public service as utility property. And they do not meet the definition or the intent of the acquisition premium that the village would propose you should disallow. In this very unique, and I would say perhaps unprecedented situation, but consistent with longstanding principles of the commission's decisions in the past and basic economics, the rate base should be the fair market value at the time that the assets became part of the regulated utility. Of course, as a practical matter, no purchaser is going to ever buy these assets if it cannot earn a return on its investments. Also, as a practical matter, and perhaps most tellingly, allowing the rate base for parking and barge to be their allocated fair market value will not materially change the current rates being paid by customers that the commission approved in its December 30th order. As the evidence will show, a transfer of the certificate to Sharpview is far more beneficial to customers than the status quo of its ownership in the hands of the estate. Risks and costs are minimized by the regulatory conditions and the authority that this commission has, and the methodology for setting rate base should allow Sharpview to earn a reasonable return on the fair market value of the newly regulated parking and barge. We thank you in advance for your consideration of these issues.
Yes, good afternoon. This is not the usual certificate transfer proceeding. For one, the purchaser is a private equity firm, and they're not in the utility business. They're in the money-making business. They see an opportunity here to make piles of it on the backs of the captive public. Sharpview is not like other private equity buyers that you may be familiar with. That is firms with large dedicated infrastructure funds with a clear intent and track record of holding utilities and operating utilities in the long term. None of that exists here. The only thing Sharpview is offering is a new owner. One which is built around an incentive structure that will reward maximizing return on investment, not on providing public service. They have no experience in operating regulated utilities. They have no specific plans or commitment to upgrade services should they acquire the system. The village doesn't begrudge people making money. Their concern is with a transaction which on its face promises to be disruptive to the utility operation. The village understands the Mitchells want out, and that's fine. The village stands ready to help with that, just like they helped with the water and sewer transition a couple of decades ago. But it's not appropriate for Limited to try and strong arm a result that does not advance the long-term best interest of this essential lifeline monopoly service. Sharpview's own testimony highlights the peculiar situation that we're in. They say they'll, and this is in their testimony, they'll suffer a forced loss of major proportions. Financial liability transfer will be destroyed if they can't put the acquisition premium into rates. In other words, their plan is dependent upon raising rates or selling piece parts to the highest bidder. I don't know how else to read that. They built a house of cards. Their business plan is reliant on extracting revenues beyond what's permissible under standard rate-making principles, as recognized by the public staff in this testimony. The village fears that approving this transaction will put us on the road to a situation that Sharpview itself admits is not viable, or which will lead to the dismantlement of the consolidated operations. You'll hear from the village's witness, Mr. Lloyd, who operates an investment banking firm in Greensboro, who works on the inside of private equity transactions. He will testify it's highly unlikely that Sharpview could hold these assets on a long-term basis, and he'll testify about the strong economic incentives built into the deal for Sharpview to take the short-term approach. You'll hear from Julie Perry, who discusses the Commission's historic treatment of acquisition premium and mergers and acquisitions, and her calculation of rate base for the consolidated operations. You'll hear from the village's witness, Dr. Wright, who will speak from the point of view of a regulatory expert to the traditional three-part standard applied in this case. He'll explain how this test has not been met, and specifically that there's no showing of public benefit. Finally, you'll hear from Council Member Scott Gardner. He'll testify from the perspective of the public. Significant that there's no evidence of widespread public buy-in to this transaction. The lone voice supporting the deal, Mr. Drumheller, has withdrawn his testimony. Numerous citizens have stated their concerns, including a survey of 1,500 property owners where 78% of the respondents either opposed or didn't have enough information to support it. Now, the village was hopeful that the Commission's order in the sub 21 docket would lead to clarity for all the parties, perhaps provide a baseline for a mutually acceptable outcome. But Limited and Sharpview have chosen a path of denial and litigation, have refused to accept the Commission's order. Just like Limited refused to accept the concerns expressed by the local government commission as regards the prior version of this transaction. It may sound counterintuitive, but the quickest path to a long-term solution that works for all parties and promotes the public interest is to deny this transaction. We're deeply appreciative of the commission's and the staff's time and efforts in this and the prior related proceeding. Thank you.
Any other?
Thank you. We call our first witness, Mr. Charles Paul III.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Mr. Paul, would you please state your name, address, and position of employment for the record?
Sure. Charles A. Paul III, Chad. Business address is 6 Marina Wind on the island and 1301 Ferry Road from Southport for the Southport assets. My personal residence is in Wilmington, North Carolina.
Have you caused to be pre-filed in this docket direct testimony consisting of 14 pages in question and answer format?
Yes.
Was that testimony prepared by you or under your direction?
Yes.
Okay. If you were asked those same questions today, now that you are under oath, would you provide the same answers as in that pre-filed testimony?
Yes.
Do you have any corrections or additions to your direct testimony?
Not at this time.
Okay. At this time, I would ask that the direct testimony pre-file be moved into evidence. Mr. Paul, have you prepared a summary of your pre-filed direct testimony in this docket?
Yes.
By agreement of the parties and direction of the commission, we will not ask you to read that summary into the record,
Thank you.
but ask that the commission accept that summary of the testimony that has been distributed into the record, and which will be filed with the clerk's office later today. The witness is available for cross-examination.
Good afternoon, Mr. Paul.
How are you?
Marcus Trathan on behalf of the Village of Bald Head Island.
Good to see you.
Mr. Paul, if I could start with a bit of a homework item. Do you recall attending the public hearing in Bolivia in this proceeding on November 1st?
Yes, I do.
And do you recall a citizen by the name of Brent Belch testifying? Brent Belch
I don't recall that specific person, but I was there and do recall the people that spoke, yes.
Okay. And do you recall, this may jog your memory, Mr. Belch had a number of concerns about the transaction. One of the specific concerns was with regards to the cost of dredging, whether the spoils basin was at or near capacity, and whether there was a plan for addressing that. Do you remember that?
Yes, no, I know, I do recall that gentleman, yes.
Okay. And do you recall at the end of the hearing that the presiding commissioner asked BHIT to follow up with Mr. Belch about that?
I don't recall that specifically, but we did follow up in terms of we know what we can do at Deep Point with the dredging, but I don't believe we did any formal follow-up with you on that. But if we do owe that, we will clearly provide that.
And we will file with the commission, if we haven't already, a more recent dredging spoils allowance survey. I believe that's been completed, and we will file that before the end of this hearing. So that's part of the record.
That would come back. I would make the same commitment that we had with the legislature and the Baldwin Island Transportation Authority that whatever we needed to have for spoil island capacity at Deep Point, we would provide. And I don't quote me off the top of my head, Mr. Tratham, but I believe it was to provide 30,000 cubic yards of space in that spoil island.
Okay. So let me just refresh your recollection at the conclusion of the hearing. Presiding Chair Duffley, I'm reading from the transcript, page 106. I'd asked Bald Head Island Transportation to contact Mr. Belge about the dredge spoil issues. Mr. Stiers, absolutely. Commissioner Duffley, and update him. Mr. Stiers, be glad to. Commissioner Duffley, as soon as possible. Mr. Stiers, certainly.
We failed to do that.
Okay, I thought I heard you say that you had followed up.
No,
with
I
him.
didn't. We failed to do that with him specifically. I remember there was correspondence for us to provide that to the commission. But I did, if we committed to contact that individual directly, we did, I failed to do that. I would suggest that any citizen or customer that has reached out to me directly gets contacted directly. So if we committed to do that at that hearing, and I committed to do that, we failed to do that.
Mr. Paul, you are managing partner of Harbor Island Partners. Is that correct?
That's correct. That's been an entity that I've owned and been involved with since 2000.
And that's a private equity firm?
That is my private family-owned business. Correct. I'm 100% manager and partner in that. Yes.
Okay. And that's a going concern?
Yes, it is.
And you have a background in investment banking?
Yes, I do.
And as I understand it, you were on the Banking Commission where you were appointed by Governor McCrory?
Yes, I served 1.5 terms. Yes.
And that's where you met Mr. Roberts?
No, that's not where I met Mr. Roberts.
Okay, so you said that in your direct testimony?
I met Mr. Roberts through another transaction, Piedmont Bank Holdings in Vantage South. He and I served together on the Banking Commission at the same time, but I did not meet Mr. Roberts through the Banking Commission. I met Mr. Roberts right around 2010-8 in terms of our business relationship as it relates to Piedmont Bank Holding Companies and Vantage South Bank.
Okay. And is that the only prior business relationship that you've had with Mr. Roberts?
Those would have been the two professional relationships that I've had with Mr. Roberts, Piedmont Bank Holding Companies, Vantage South, and the Banking Commission. Correct.
Okay.
Notwithstanding that when we were working with the legislature on the legislation, I did visit with Mr. Roberts and Governor McCrory at the time regarding the legislation for the authority. But I had known Mr. Roberts prior to that meeting, but that would be a third professional, for the lack of a better word.
All right. You are CEO of Bald Head Island Limited,
Yes, I'm CEO of Baldwin Island Limited and manager of Baldwin Island Limited.
and Limited is ultimately owned by the Mitchell estate.
Correct.
Are you authorized to speak for the Mitchells?
I am authorized to speak for Baldwin Island Limited as it relates to their ownership of Baldwin Island Limited. Yes, I cannot speak for the Mitchells on any other matter.
Okay. Are there any of the Mitchell family members here today?
No.
Do you have 7, 8, and 12? If we could approach, I have 3 exhibits that I'd like to hand out at the same time.
You may.
Madam Chair, I would prefer to just mark this as 1 exhibit rather than 3, if that suits your pleasure.
Yes, that's fine.
Okay, could we pre-mark this as Village Hall Cross-Examination Exhibit 1?
It will be marked as Village Hall Direct Cross Exhibit 1.
Right, Mr. Paul, these are just 3 short articles that discuss Mr. Mitchell's death. And since we've been talking about him, I thought it would be helpful to give a little bit of just short introduction of who we are talking about. If you could turn your attention to the document that's labeled The Big Story. This has this looks like it's an AP article from July 2013, which is republished by the Mitchell Foundation. Do you see that?
Yes, sir.
And this states that Mr. Mitchell's company, Mitchell Energy, was credited with over 200 oil and 350 natural gas discoveries. Do you see that?
Yes.
Spent 2 decades developing hydraulic fracturing, finding success in the Barnett Shale Formation in the 1990s. Do you see that?
Yes.
Is this consistent with your understanding of Mr. Mitchell and his business activities?
Among other things, yes.
And do you see on the second page that Mr. Mitchell sold his company in 2002 for $3.1 billion?
He sold one of his companies. Yes.
Okay. And then down below, this article states that he's on the Forbes list of wealthiest Americans, ranked 239th with net worth of $2 billion as of 2013. Is this consistent with your general understanding?
Yes.
Okay. The second article in this exhibit, just draw your attention to, it's a Wall Street Journal obituary and labeled "Father of Fracking," dies in 94. Do you see that?
Yes.
And have you heard Mr. Mitchell referred to as father of fracking?
Yes, I have.
Yeah. And then the third is just simply a Wikipedia entry that it's essentially repeating some of the same information. It also talks about his real estate development activity with the Woodlands and his hometown in Galveston. Is that all consistent with your understanding?
Yes, you focus on his fracking and his oil and gas, but he is just as well known in the development industry for conservation and development as being one of the preeminent leaders in conservation and development, to include Baldwin Island, an island that's 12,000 acres, in which he donated 10,000 of those 12,000 acres and turned it into electric only in the 1980s, before green became green.
Okay. So, Mr. Paul, With respect to Bald Head Island Limited, my understand is that company is owned by Mitchell Island Investments, Inc. Is that correct?
That's correct.
Okay. And Mitchell Island Investments, Inc. is in fact the entity which is owned by Mr. Mitchell's estate, correct?
It is owned by an entity that's part of the Mitchell estate, correct?
Okay, so what's the name of that entity that,
It's Miss Mayfield may recall when you talked to her, but I think it's a management company. It's a Mitchell management company that's tied to the estate.
okay, so there's two layers of corporations before you get to the estate.
Correct.
Okay. And Limited itself is an independent going concern, correct?
Correct.
You're actively doing business.
Yes.
The company is solvent.
Yes.
It's profitable.
Yes.
If we could hand out another exhibit, please.
Yes.
At 36. Mr. Paul, this is marked confidential attorney's eyes only, but I believe that this falls in the category of historic financial information of Limited. I'll let your counsel assess.
As soon as I see it.
So, Mr. Trathan, notwithstanding the heading and the reference, this would have come directly from items relative to the authority with the legislature.
And therefore, I just want to make sure I understand.
It's okay to not have it.
Yeah, so this is
for-
not confidential.
But for the headings and the moniker on it, this would have come directly from the authority and its history. So this is out there. The whole
Not-
world has this.
Not confidential. Correct. You may ask questions.
So it's a non-confidential exhibit. Let's go ahead and mark it.
Yes, would like to mark this as a village, see if I can get this right. Paul, direct cross-examination exhibit number 2.
The exhibit consolidated historical income statement shall be marked as Village Paul Direct Cross Exhibit 2.
So Mr. Paul, this is a statement of the historic financial results for the transportation operations. Am I correct?
It's a historical consolidation of the ferry and tram, the parking and the barge. Yes.
Okay. So this does not include the other business activities?
No, it does
of
not.
Limited.
No. And this would have been put together in conjunction with the authorities, advisors, Davenport, and would have been primarily UBS.
Okay. And this, in terms of the gross profit numbers, these are true and accurate as far as you know?
Looking at this and not having been able to go back and look at the audits, I would say that this would be consistent with that review. But I can't speak to the fact that what SharpView may or may not have done with pulling these numbers out and making changes. I don't believe they would have done that, but these look like it would be consistent because I arrived in 2010. So I've been CEO and manager since 2010, October.
And I hear you saying that the numbers, I mean, you're not going to speak to the exact dollar number, but generally speaking,
This would be the trend.
this is the trend. Okay. With respect to the other business activities, in the sub 21 docket, we sent you a discovery request and we asked you about assets that would be owned by Limited after the sale of the transportation assets. And you identified a list of 20 different assets. I've got an excerpt with your response here and would like to hand that to you.
Sure.
if we could mark this as a village poll direct cross exhibit number 3.
So marked. And at the bottom of this exhibit, it has the
Yes.
words confidential.
Yes, this was identified as confidential and not attorney's eyes only, but regular confidential, if you will. I don't necessarily need to get into the details. I could just ask from the document itself if this remains confidential.
I think where I am on this, Mr. Stiers, is I'll be happy to answer questions in general, but if we want to go to specifically, for example, number 14, and we get into what number 14 actually is, I think we need to, that needs to be confidential. So if
Okay.
we want to talk in general about where we are, like, hey, how many lots, residential lots, things like that are left that we're working on, I can do that. But if we're going to be specific about an item here, we probably need to keep that confidential.
Okay, let's work our way through it. And
Okay.
And please note for the court reporter, this is a confidential exhibit. However, there can be non-confidential questioning.
Okay, so Mr. Pohl, do you recognize this list?
Yes, I do.
Really, I'm just trying to get a sense of the remaining assets after the sale. Does this remain an accurate list? I think you provided this in July.
This is consistent. We've been very busy since then. So there are assets that we have transferred and sold since then that are on this list.
Okay, could you just,
So for example, we have sold probably 6 to 8 of the residential lots in number 1. We probably have sold 3 of the commercial lots and tracts that are in item number 2. We have sold 1 of the PUD commercial tracts in item number 3. We have a transaction right now that we're pending on another one of those PUD commercial tracts. We are working through the non-buildable land tracts, so that number is still correct of 54. Number 6 is still alive and well. Number 7 is still alive and well. Number 8 is for sale. They are not sold yet. Number 9 is consistent, notwithstanding we did some transactions in number 1 that brought that number down by 4 or 5. Number 10 is still consistent. Number 11 is still consistent. Number 12, 13, 14, 15, 16, 17, 18, 19, and 20 are all consistent.
okay, thank you, Mr. Pohl. Are there any other business activities of limited which are not reflected outside of the transportation activity assets and that aren't reflected on this list?
Yes, absolutely. There's the Bald Head Island Marina operations, the Bald Head Island slips that we still own, that Mr. Roberts and Sharpview are buying, the mainland Deep Point Marina operations and slips, the mainland shipping and receiving operation, the on-island golf cart parking and leasing operation, four commercial properties that are not part of the count here on the island, and the balance of the development land on the mainland at Deep Point. That's just off the top of my head, Mr. Trathan.
Understand.
When it's over, if it does happen, Sharpview will have more invested in the island than adding all these up than the Mitchells will.
Okay, the 76 million, is that what you're referring to?
The transaction with Sharpview was 67.2 million.
67 million. Okay, in the sub 21 case, there was testimony with respect to development on Indigo Plantation, and Limited is still engaged in that.
Yes, we are.
Okay. Mr. Paul, we sent you a discovery request. There's a reference to the continuation of services, and we asked whether or not Limited was threatening to discontinue utility services, and you responded in your data response. No, BHIL has no plans to discontinue utility services, has never threatened to do so. BHIT has operated the regulated utility since 1993, has an exemplary record with the commission dating back 30 years in its operation of the regulated utility. Is this still your position?
Yes, it is.
Mr. Paul, with respect to the sale of these assets, there have been, aside from Sharpview, there's been two potential public buyers, correct? The Transportation Authority and the village itself.
That's correct.
And with respect to the village, you've initiated litigation against the village, essentially to seek, you're seeking a ruling saying that the ROFR is either invalid or extinguished. Is that right?
That's correct. You were involved in all those discussions and meetings, Mr. Trathan.
I sure was. Am I correct that there are pools of federal money, especially, which are available to public owners of transportation assets that are not available to private owners?
Until very recently, that's the case. So, for example, with the infrastructure bill that came to the federal legislature, they modified those rules, and we recently just received a $185,000 grant for new engines in the Ranger. So historically, ballparks, the way it worked is the Federal Highway Trust Fund has money allocated. The maritime aspect of the Federal Highway Trust Fund, which is where we could apply, has had $600 million or so sitting in there for years. But only public entities have access to it, not entities that are publicly regulated, but only public entities. That created a difficulty for us to seek things like a grant for new vessels, which the state DOT was able to do with their recent transaction. However, with the infrastructure bill that was passed, those recently were loosened. And all the money ends up going from the federal government. Even though you apply directly to the federal government, it runs to the state of North Carolina, and you actually get the money from the state. So historically, that's correct, Mr. Trathan. But recently, we just received, I think in the last week or two, news that we did receive $185,000 to repower Ranger.
So, Mr. Paul, with respect to the Sharpview acquisition, I believe you've stated that you're looking for a buyer that will carry on the tradition of the limited. Is that right?
The stewardship aspect of what Mr. Mitchell created, yes, that's the goal.
Got a exhibit I'd like to hand out. if we could mark this as. Oh, thank you. Yes, this I believe would fall within what we discussed earlier as confidential AEO, and as I understand the parameters, this would elicit information which has been designated as such, so.
Yes, this information is part of information disclosed that were investor alternatives. And so it is marked confidential AEO, and we would like to maintain that confidentiality.
So I think we would need to go into confidential session for this line of questions.
Okay, thank you. Do we want to hold this until the end?
No.
Before we do that, I don't believe there's been a foundation laid yet, to my knowledge, that Mr. Paul prepared this document or has any independent knowledge of its information. He may or may not have seen it. I don't know if there's a foundation for him to answer questions as it pertains to this document. Since it's not his document, he didn't produce it. Yeah, I don't know at this point.
No, I didn't produce this document. I would also suggest that, for example, Mr. Tratham, the title to number 5, what is management's business plan? I would suggest that that was not drafted by myself. That's not drafted by myself. I can speak to some of it, but this is not. I didn't draft this document.
Okay, well, I'm got questions about it, and I think you can speak to it.
Okay, I'd be happy to do that, but it's not my document.
Okay,
At
so,
this point, I'll make a register an objection that there's not been a foundation laid, that this witness has a knowledge of this document or can speak to it, since he didn't prepare for it, and to my knowledge, don't even know if he's ever seen it before.
okay, I hear your objection. I'm going to allow the questions to be asked. We're going to head into confidential session. Please designate everyone, Mr. Farrell, that needs to leave the room. And Mr. McCoy, if you could move us into confidential session. So it is now about 3:30. We're going to take our afternoon break and we'll be in recess for 10 minutes. Be back at 3:38.
Straight.
Mr. Tratham, do you have further questions?
No, I do not.
Okay. Mr. Higgins?
Yes, ma'am, thank you. Mr. Paul, a couple of questions following up on your exchange with Mr. Trade, and I'd like you to, I want to be sure I understand this. Would you look at cross-examination number 3, which is this asset list?
Yes, sir.
You with me?
Yes.
Are these assets that Limited is going to retain? Or are these assets that would be conveyed as part of this transaction?
These assets are not being conveyed as part of this transaction.
So-
These are still within Limited.
I see. And likewise, I think you mentioned like the Indigo Plantation Marina, there are other assets that Limited owns as well?
Correct. Presently, we own.
Okay.
Some of them are under contract, but yes.
So the sale of the ferry and the transportation operations and assets won't close out the Mitchell Estates holdings in North Carolina, will it?
It'll close out all the operating entities,
Okay.
and there will be some remaining real estate entities, but the majority is being sold to Sharpview.
And the real estate development entity for the Indigo Plantation project, is that going to be?
That'll be an outright sale to a third party that's under contract right now.
Okay. Fair enough. I have some questions about your amended direct testimony. Do you have a copy of that in front of you now?
Yes, sir. Thanks to you.
Page 6, line 5. You state there that ferry ticket prices have only been raised once since, I think it says 1995. I thought it was actually 1993.
I think you're probably right.
Since 1993. Is that because the only time BHIT ever filed a rate case or requested an increase was in 2010 after the Deep Point Ferry Terminal was put into service?
That's my understanding, yes. Deep Point went into service, I believe, in the summer of '09.
I think that's probably right. Would you agree that the availability of the ferry service at reasonable rates was an essential component of Limited's plan for development of Bald Head Island and the sale of lots and homes on the island?
I think that's consistent with Mr. Mitchell's vision, yes.
There's been some reference in the testimony that's been filed regarding the inability to get, the ferry authority's inability to get LGC, Local Government Commission approval for the bonds that were necessary for that purchase. You've referred to that on page 11. I'm looking at line 15. Tell me when you're there.
I'm there, yes, sir.
Is the reason the ferry authority was unable to get LGC approval, is that the LGC posed questions that either BHIT or the authority couldn't answer to its satisfaction?
Objection. The question as asked the witness, the motivation of the LGC. He does not have knowledge of why the LGC, he knows what the LGC, or may not know what the LGC said or didn't say, but not what motivated or what was in the minds of the LGC members.
Fine, I'll ask him what you understood the reason was that the LGC didn't issue the requested approval.
They felt that the purchase price was not thoroughly vetted by the authority.
Did they think the purchase price was too high?
I think there was one member of the LGC that indicated that that was her opinion. However, I believe it was that the authority needed to substantiate better the purchase price.
You say in your testimony that Sharpview has contracted with you to continue to manage, basically continue to manage everything that you manage right now for the next 3 years. I'm on page 12. If you're
Right,
looking
I'm
for that.
talking just in terms of contract. I don't have a contract. I have a general understanding with Sharpview and the Mitchells that I will stay for a 36-month period of time to manage the transition.
Do you know why it is a 36-month period has been specified?
No, that would have come out of the authority transaction, but I would suggest that the items that you talked about on the previous exhibit, the remaining items, it's going to take probably 24 months to work through those 20 items.
When you're talking about this list of
Correct.
20 items that,
This list, there will be crossover obligations like I have right now between transportation of the limited items. It's going to take that long, so I'm going to be there. So that would kind of coincide with that period of time, because it'll take probably at least 24 months to just handle this list of 20 for the Mitchells.
just to be clear, what you're saying is you're going to be there for at least 24 months doing the business of limited with
Yes.
regard to these.
Doing the
assets.
same business that I'm doing right now. Correct.
Page 14, line 6. You see your testimony there, beginning on line 6?
Yes.
Is it still your understanding that Sharpview will not request any rate change because of the acquisition transaction, and that any rate changes it pursues in the future will be unrelated to financial factors associated with the acquisition transaction?
No, when I look at this here, let's see here. Yes.
Thank you, sir. I don't have any other questions.
Public staff?
Mr. Higgins had some questions that related to what I was going to ask, especially clarifying on at-will scenario. So I'll move on to the next question I had, which relates to the residual assets that the Mitchells will own, like declarant rights or otherwise. And can you let us know your understanding, confirm that their continued use of those assets would not impact ratepayers of the regulated utilities?
That's correct. So, Mr. Creasy, I want to be very clear as we've talked in the past. So, for example, stormwater permits and CAMA permits, they cover more than just the assets that we're talking about in this. We will have to go to those respective state agency and break them up and specifically apply those to the pieces. That's what's going to take a period of time, but that's the intent. So it's not like parking will be left without a stormwater permit for parking. We'll have to go to the agency and take that stormwater and design it to make that permit specific to parking and specific to barge and specific to the ferry and the tram. Whereas right now it covers the entire campus to include the residential marina and the excess development land.
All right, thank you.
Redirect.
Few questions, Mr. Hall. Since we're kind of been on it, let's go ahead and stay on it. The Exhibit 3, which is the list of the properties. The Mitchells estate's intent ultimately is to liquidate and sell and be rid of all of these properties over time. So these are properties that are not being purchased by Sharpview. The Mitchells are still in the process of liquidating assets here on Bald. Is that correct?
Yes, and some of the assets that are listed here have already been sold.
And so this is an ongoing process of selling all these assets.
It's full liquidation.
Okay. There were a number of questions, pertaining to cross-examination Exhibit 1 and Mr. Mitchell himself individually. And actually, the Wikipedia excerpt has on page 3 of 7 a discussion of the Mitchell's philanthropy. When assets are being liquidated, are the cash proceeds going into the Cynthia and George Mitchell Foundation?
The majority of the proceeds are going to that foundation, yes.
Okay. To your knowledge, have the Mitchell's oil and gas holdings now been sold and liquidated, to your knowledge?
Yes, to my knowledge.
Okay. Mr. Mitchell owned most of the commercial district of downtown Galveston at one time, did he not, through
That's
various
correct. He
entities?
was the majority owner of downtown Galveston.
Has he now liquidated and sold, to your knowledge, all of those operational assets in Galveston that were part of the commercial district there?
I believe they so, but I can't say every single one. I think at one time it was 21 buildings. I don't know if all of them have been sold or not, but the intent is to liquidate everything.
So is it fair to say, that the operational assets that the Mitchell's companies owned have now been liquidated and the funds transferred to the Cynthia and George Mitchell Foundation in general?
Yes, operating assets, the only ones that remain are the ones on Bald Head.
You were asked about the data request response in which you said that the Mitchells have no plan to discontinue service.
That's correct.
Okay. Does the Mitchell estate have a plan for what to do with these assets if this sale does not close to Sharpview?
Not that they've shared with me.
Okay. Are they in a position to continue to make capital investments for capital improvements to the system over time?
Not to my knowledge in terms of a plan, no.
What have they told you about being in a position to make capital investments for the system?
That they're not in a position to make those investments for like new ferries, to lay up a new ferry.
You had referenced the public funds received for the engine for the Ranger ferry, is that correct?
Correct. We received $185,600, which I think represented about 40%.
Just for purposes of clarification, that wasn't a DOT or
No,
infrastructure.
not
Act
DOT.
program.
It came out of the EPA through the infrastructure bill. Correct.
Okay, it was the Diesel Emissions Reduction Act, correct?
Right. The diesel engines that are going in there, the current rating is a 1. They'll go to a 3, less emissions.
Okay. And so I just want to make sure the record is correct, that that's administered through the state of North Carolina, correct?
Correct.
Okay. So one of the assets on this list was the Bald Head Island Construction. Is that a company that will eventually be sold and no longer owned by the Mitchell estate? Is that the intent?
Yes.
Okay. Also, Bald Head Island Limited Real Estate Sales, that company is also intended to be sold?
The developer sales, yes.
Okay.
Frankly, Mr. Stires, both of those will probably be wound down. They probably won't be sold.
Okay. It just wound down.
Wound down in the course of working through these other assets.
So long-term, there will come a point in time when the Mitchells will have no more interest in Bald Head Island. Is that correct?
The Mitchell estate.
Mitchell estate, excuse me.
There are some
Some
children that have
houses.
homes on the island. Yes.
But the Mitchell estate, from a business perspective, will long-term no longer have any operations, any assets as a business enterprise in and around Brunswick County, North Carolina. Is that
In
correct?
all of North Carolina that I'm aware of.
Okay. And I think you've probably answered this sufficiently in response to Mr. Higgins' questions, but you have represented to Sharpview your intentions to stay on for 36 months.
Up to
after closing.
36 months.
Okay. No further questions.
Okay, commission questions? Commissioner McKissick.
And this is just for a point of clarification. And this is dealing with that document that's been referred to as Exhibit 3, Village Cross, Direct Exhibit 3. And there's been considerable time going down this list of assets that continue to be owned by the Mitchell estate. I think you've identified some that have been sold. Like, I think under number 2, you indicated that 3 of those lots were sold.
Yes, sir.
And under number 3,
One of those has been sold.
One sold, one pending,
Yes,
and under number 1, 3 sold,
I think it's 5.
5
Rick, is it?
sold. Okay, now, let me ask you this. Under number 10, why would they be selling that?
This list is about what would be remaining that's not being sold to Sharpview.
Oh, right, right.
Right, so most of those purchase money mortgages have left less than 5 years left on them, but these will be left over,
Right.
not sold. So
They would retain those. There's no
they're
reason
going to
for them.
retain those. The context of this 20 is that there are issues and entanglements associated with these 20
I
that make
see
it difficult to go and sell it to a third party outright without disentangling. And the purchase money notes primarily are with the club, and
Got
they're
it.
entangled. So I think there's no intent to sell those notes. I think that the estate will just keep that working through with the club.
Well, that's why I was wanting to clarify that, because when it was stated that at some point all of this would be sold, it occurred to me that that's one that likely would not be
It'll
sold.
burn out. It'll burn out. And like I said to Mr. Stiers, that we'll probably end up just shutting down in the construction business and shutting down the developer sales business.
Okay. So that's an asset that would remain. There would be no purpose or intent.
Correct.
And the rest of these, they work through whatever the entanglements are
Correct.
with the intent and goal of selling them if there's a willing buyer to purchase them.
Or, for example,
Yeah.
number 5,
Yeah.
finding the right home, which might be the conservancy, it might be the state property office, it might be, the land trust on the non-buildable pieces.
And well, I don't want to get into the details, number 14. That's clearly an entanglement situation.
That is a significant entanglement situation.
And that's not really something that can be sold.
It can be solved. It takes time.
Really?
So, for example,
I think, I make sure I understand. He said, did you say sold or solved?
solved. I heard solved. I'm sorry.
Yeah, I think it can be solved,
Yes.
but you wouldn't be selling it.
No, you can't really sell those.
Exactly.
Right.
You can't sell it.
Right.
Just
Yeah.
want to clarify.
Yes, sir.
That's another
No,
asset
that
that
would
can
be,
be sold.
so somebody buying a piece of property would need to have their share of that as a condition.
I
Correct.
understand.
Right.
That's why I just wanted to clarify. Certain things here
Can't
cannot
be sold. Correct. This list is what's left over
Right.
after Sharpview does it. We'll have, some will be sold off, some will be wound down, some will be transferred.
Exactly. And here it would just be untangled
Correct.
so that the recipient would be able to continue current operations.
Absolutely. In terms of the discussion here,
Yes.
that is the intent.
Got it. Just want to make sure for the record. Thank you.
Other questions? So I have just a couple. On page 6 of your testimony, you're talking about the assets, lines 12 and 13. You talk about each of the trucks and each of the passenger trailers. And it's just a general question about what's the status of each of those trucks and passenger trailers? Are they near end of life?
So it's Bragg. So for example, I think if I'm not mistaken, Miss Mayfield can confirm exactly, but I believe we have 4 new trucks coming on board right now. We pretty much bring on 3 to 4 new trucks a year and cycle off 3 to 4 trucks a year. And that process is about a 7 to 10 year period of time.
Okay, thank you for that. And then the
Definitely ask her, Miss Duffley. I think it's 4 this year, but it might be 3.
Okay, thank you. And then these Bald Head Island operated shuttle for the contractor services, those are different vehicles than the
No,
23 tram?
It used to be, they used to be buses,
Mm-hmm.
but they were big and they were problematic. So what we did is we bought trams for them and we
Okay,
flagged them. They have a red canvas.
but they're inclusive of these 23?
Yes, they are. They're
Okay,
inclusive.
thank you. And then on page 10, you talk about how historically you've kept different financial books for the different entities. Do you plan on keeping the financial books separate pending the appeal?
Yes.
Okay. And then my last question is on page 14. you and Ms. Mayfield have this 36 months. Have you created a succession plan after the 36 months, or you think you have enough time to do that?
I think we have enough time to do that. We haven't created a succession plan.
Okay, thank you. Those are all of my questions. Questions on commission questions?
I do not.
I do not.
Okay, thank you, Mr. Paul. You can step down just temporarily. You may call your next witness.
Thank you, Commissioner. We would call Shirley Mayfield to stand.
Do you swear that the testimony you're about to give today shall be the truth, the whole truth, and nothing but the truth, so help you God? Before we start, were there motions that anyone wanted to make?
Yes, let me go ahead. Thank you, Commissioner. That's an excellent point. First of all, and to the extent it hasn't been moved into evidence, I'd like first, I have three motions, that the pre-filed testimony of Mr. Paul and the summary be moved and accepted into the record as evidence in this docket.
You have moved that, and those have been accepted and received into evidence.
I would like to also, while I'm at this point in time, I'd like to go ahead and move the amended application from what's the date? I want to confirm the date.
January 21st, 4th, 2023.
That's correct. The amended application filed on January 24th. I'd like to go ahead and move, that was verified by Mr. Paul. I'd like to go ahead and move that into the record at this time as well as the exhibits. Exhibits E and F remain confidential, but I'd like to go ahead and get them into the record as evidence at this time.
Okay, without objection, the amended application filed on January 24th, 2023 will be received into evidence, as well as Exhibit E and F, which will be designated as confidential.
Now, Exhibit E, which is the APA, was voluminous. And if you went through Exhibit E, you realize that even more voluminous were all the disclosure schedules. They were not attached. All the schedules and all the exhibits were, but the disclosure schedules, 4.1, et cetera, the disclosures were not part of that. We would ask that the commission receive the disclosure schedules as a late filed exhibit to make sure the record was complete with not only the schedules and exhibits, but also the disclosures. And we don't think that they're necessarily pertinent to any of the issues in the docket, but on the other hand, we want to make sure the record is complete, which would include the disclosures as a late filed exhibit.
Mr. Creech?
Presiding Chair Duffley, I've been alerted to this by Mr. Stiers, and the public staff would ask the ability to for the parties to conduct any discovery if needed on these, as well as the ability to file supplemental testimony if necessary. I've only glanced at them momentarily. I think we have a lot of this information already, but I haven't had the opportunity to look at it, so I just don't know.
Mr. Stiers, your response?
No objection.
Okay, seeing no objection that the disclosure schedules that are part of Exhibit E and related to Exhibit E shall be filed as late filed exhibit within
A week.
1 week of the end of the hearing.
Right.
And the public staff that will have the opportunity to potentially file discovery and supplemental testimony on those exhibits.
Chair Duffley, would it be possible for those to be filed sooner than that? I mean, really as soon as possible, and we want the ability for all the I mean, we're not the only only group that will be looking at these, and so I don't know whether other folks would want the ability.
We'll file those disclosures tomorrow.
Okay. The disclosure schedules will be filed tomorrow as a late filed exhibit.
And, excuse me, Commissioner Duffy, and to Mr. Creech's point, would at least theoretically other party interveners be able to pose discovery as well with regard to those?
Yes.
Sure, no objection. And finally, there is my understanding is there is a new spoils survey updating the exact capacity as of, I think, the last survey in December. And we'll also file that this week, the new spoils all out survey that was not filed after the public hearing, but we want it to be part of the record, and that'll be filed this week as well.
Without objection, the spoils survey will be filed
This week.
by Friday
Yes.
of this week
Correct.
as part of the record.
Madam Chair, like to move into evidence the 4 cross-examination exhibits offered by the village.
Without objection, the Village Paul Direct Cross Exhibit 1, Village Paul Cross Exhibit 2 will be introduced into evidence. Village Paul Direct, without objection, Village Paul Direct Cross Exhibit 3 and Village Paul Direct Cross Exhibit 4. Both have been designated as confidential, and those will be so marked in the record and will be received into evidence. Okay, now I think we're ready to begin.
Thank you. Ms. Mayfield, will you please state your name, address, and position of employment for the record?
Shirley Mayfield. My address is 6 Marina Wine, Bald Head Island. That's my registered business address. My position is Chief Financial Officer.
Chief Financial Officer, just so the record's clear, for whom?
I'm sorry, for Bald Head Island Limited LLC.
Okay. Have you caused to be pre-filed in this docket direct testimony consisting of 5 pages in question and answer form?
Yes,
And was that testimony prepared by you or under your direction?
it was.
If you were asked those same questions today, now that you're here under oath, would you provide the same answers as in your pre-filed testimony?
Yes, I would.
All right. Do you have any corrections or additions to your testimony?
No, I do not.
At this time, Commissioner, I would move into admission into evidence the pre-filed direct testimony consisting of 5 pages in question and answer format.
The direct pre-filed testimony of Shirley Mayfield will be received into evidence and treated as given orally from the stand.
Ms. Mayfield, have you prepared a summary of your pre-filed testimony that's been filed in this docket?
Yes.
All right. Commissioner, we've passed out a copy of that to everyone, and we would ask that her summary be filed in the record in this document. We can make that filing this evening.
Okay, the summary will be received into the evidence.
And the witness is available for cross-examination.
Good afternoon, Ms. Mayfield. Marcus Trathan for the Village of Bald Head Island. So my understanding is that you have a handshake agreement to stay with Sharpview for 3 years if the transaction is consummated. Is that right?
I have indicated I would stay, yes.
Okay. But there's no written agreement.
No, sir.
Okay. And so I'm going to ask you some of the same questions that I asked Mr. Paul, so this won't be a surprise. Will you receive a bonus or any incentive compensation from Limited if this transaction is consummated?
That would be a decision Limited, but still need to make.
Okay. All right. And with respect to Sharpview, same question. Do you anticipate receiving any sort of bonus from Sharpview with respect to the closing of this transaction?
In all honesty, it would be way premature for me to say yes or no. I have had no discussions whatsoever.
Okay. And there have been various investor presentations, and you may have heard some questioning and with respect to Mr. Paul that discuss management's intention to invest in the transaction alongside co-investors. So my question to you is, have you communicated an intention to invest in the transaction?
No, sir.
With respect to your employment, I think I know the answer to this, but have you discussed your participation in Sharpview and your employment and participation, the receipt of performance fees or carried interest or sponsor equity, anything like that?
No, sir. I have not.
Okay. And have you seen draft operating agreements for SVC Pelican Partners with a placeholder with your name on it for capital contribution and carried interest percentages?
No.
Okay. So the management case, you were here for the cross-examination of Mr. Paul.
I was.
And that was a confidential discussion. I just want to ask a quick question. I don't think it'll elicit confidential information, but have your antenna up. Are you familiar with the management case that we were discussing with Mr. Paul?
Not to the detail that Mr. Paul was.
Okay.
I don't have the depth in that he does.
Okay. Were you part of the management that proposed this business case?
Yes. Or well, you're talking specifically about the business case in Sharpview's document.
Yes.
No, sir.
Okay. We could point out the exhibit, please. I need a copy. I note, Mr. Stires, that this is labeled confidential. It's a limited production, so I think it falls within historic information.
Mr. Chapin, you want to identify the document?
Yeah, I'd like to identify this as Village Mayfield cross-examination exhibit number 1.
And the confidential designation?
This is not, we will waive that confidential designation for these questions.
Okay, the document at the top states Village of Bald Head Island data request number 1, request number 12D shall be identified as Village Mayfield Direct Cross Exhibit 1.
Ms. Mayfield, I represent to you that this is a data request response that we received from Limited and Transportation and Sub 21 case. I'm guessing that you may have prepared this. Do you recognize this?
Sir.
Okay. And just this question asked for the cost basis in the land at the that's used for the Deep Point parking lot. Am I correct that the figure that's stated here with respect to that cost basis is $325,000, 126?
Related to the parking lot. Yes, sir.
Exclusively related to the parking lot.
Yes, sir.
Okay. That's all I've got for that document. I would like to ask you some questions relating to Exhibit A1 to the transfer application. And I have copies here. It does not look like you've got a copy of it. Madam Chair, should I just go ahead and hand it out and treat it as a new exhibit, or?
Why don't you hand it to the witness so that she has it, but will not introduce it as a separate exhibit?
That's fine. All right, Ms. Mayfield, do you recognize this document, Exhibit A1 to the transfer application?
I do.
Okay, this is the Bald Head Island Transportation Financial Report from December 31st, 2021. I just have a few kind of specific questions relating to this. If you would go to page 4, please. And direct your attention to the management fees line showing for 2021, the amount of $146,000, $146,976. Do you see that?
Yes, sir, I do.
Can you tell me what that is, what that figure represents?
I can. Not all of the overhead costs related to the support of the landlord campus.
Ms. Mayfield,
I'm
can you
sorry.
speak into the microphone? Thank you.
Not all of the landlord costs related to the entire campus are direct billed to the various users of the campus. The same thing occurs with employee time. So there are employees who are not directly related, but yet provide support for the campus. And that would be human resources, IT, perhaps in-house legal, could be construction. It could be any number, various positions in accounting. So what we do during the budget, we determine the management fee budget. We take in all of those costs. I do a time request every 2 years to have the times looked at by the individuals involved. And then on a percentage basis, there's a salary and a benefits cost that gets transferred over as a management fee, but it goes through 2 more iterations. There is next compared to market. So once I know what internally it cost us to support an area, it is compared to what market might cost to offer that same support. And then, particularly with transportation, there are credits given against that number because of marine maintenance's support with some of the facilities in the area. But that's what that number is.
Okay.
It's outlying support.
All right, thank you. So I'm trying to figure out what the relationship between this entry, if any, and it may be that there isn't any relationship, the relationship between this and the affiliate agreement, which was filed with the commission, and it's labeled a transportation management agreement, which was originally valued at $68,000-ish. Can you speak to the difference between this number and the management agreement, which is an affiliate agreement?
I'm not sure I know which agreement you're talking about, Mr.
Okay.
I'm sorry.
Okay. You're familiar generally with the affiliate agreements? There's a lease agreement for the lease property.
Are we talking about the deep point allocation agreement?
That is one of them. That is one of them. There are several leases which were filed as between Transportation and Limited and docket A-41 sub 7 back in 2011. That's what they were amended in 2011.
Oh, in 2011. That may be, and I'd have to look back at those agreements to be sure, but in 2011, Transportation did not own the vessels, and the vessels were leased to Transportation, and there was also an operator that was leased.
I think this is different. The management agreement covers general business management, budgeting, handling employment, contracting, supplies and maintenance, permits, handling money, preparing financial statements, obtaining insurance.
Sorry, that would be the same as this would be the same as this management agreement.
Okay.
Yeah.
All right. So we're talking about the same thing. This figure is the management agreement.
Mm-hmm.
Okay. And so I'm just puzzled as to the amounts that differ between what was filed and what's on here. Do you have any?
The management agreement is renewed each year annually, depending on what type of services are currently being provided, what the costs are. So it's updated on an annual basis.
Okay. And what is your understanding with respect to who will be performing these services if this transaction is approved?
A number of these transaction services will actually go with the transaction. For example, accounting staff, HR staff, they'll be actually supported within the transaction. And certainly my assistants will be part of this oversight.
And is it your understanding that the existing management agreement will be assumed in connection with this transaction?
There will probably be some type of transition agreement with Limited during the 2 or 3 year period, yes. But the intent is that once the transaction occurs, once we work through the transition, then the transaction operations will be able to sustain themselves completely.
And you're using the term transaction operations. Help me, what do you mean by that?
I'm talking about it would not just be transportation, although that's what we're addressing specifically here. And the transaction agreement, it would also provide transition assistance to parking, barge, to the marinas. There would be a overall transition opportunity.
Okay. So what I'm trying to better understand is, will the existing financial arrangement with respect to management services, all those category of items which are specified in the agreement, will those continue to remain as they are after the transaction? I think maybe the answer is yes, but you tell me.
I would say that they were definitely going to resemble the transaction. I don't think it's been defined in detail yet. So there will be some of the same assistance that's involved here will be in that upcoming transaction. But for example, the perhaps the human resource work or the accounting work may go direct with the transaction. It would no longer be included in this transaction, in this allocation agreement or management agreement.
Okay. So if you would turn to page 6, please. And the item, I don't think it's highlighted in your copy, but advances from a related party. Are those, do you see that?
Yes, I do.
Is this the advances from Limited?
Yes.
Okay, so these are the monies coming in essentially to balance the books. If you would turn to page 9, please. So this $19 million of intercompany debt, what is that for?
That is the funding that Limited has provided to transportation over the years to support the operation.
Okay. And that is being written off if this transaction closes, that debt is being written off.
Yes.
With respect to a couple of paragraphs there, we're looking in the auditor's notes here, says that the company is dependent upon its parent to fund future operations. It says management anticipates the parent will continue to fund future operations sufficient to meet obligations. Is that your understanding? Is that statement accurate?
It does.
So with respect to the last rate case, the 2010 rate case, there was an amount which was deemed to be imputed from parking in that case. You're familiar with that? I believe it's $523,000.
Thereabouts, yes, sir.
Is that figure reflected in these financial statements?
No, sir.
Okay, and why is that?
On the parking imputation on the rate case was included solely to settle the rate case at a $23 ticket. It is not a computation that we carry forward every month.
Is the transportation operation, I assume you have a budget?
Yes, sir.
Okay. And is there a line item for capital improvements in that budget?
In the capital budget, yes, sir.
Okay. That's all I have.
Mr. Higgins?
Hi, Ms. Mayfield. Dan Higgins with BHI Club. Good afternoon. How long have you been the CFO for BHI Limited?
21 years.
First, since we're on it, let me ask you some questions about the things Mr. Traven just asked you about. Look at page 6 of the financial statement. I'm sorry, page 4.
Okay.
And so if I correctly understood your response to Mr. Traven, the imputation that was provided for in the 2010 rate case is not reflected in this calculation, correct?
That's correct.
So if the imputed amount was shown, there would have been theoretically a small profit, correct?
Yes, sir.
Also, further up on that page 4, there is, I believe, the second entry in the column is rent of 1.25 million. That's the payment for rent for the use of what?
That includes the Deep Point Marina landing, the Bald Head Island Marina landing, some portion of all the roads coming in and out, the infrastructure on the roads, the marine maintenance building, the maintenance pier, the contractor landing. Basically, what that lease covers is the portion of the entire campus that was determined to be used by transportation.
Does it cover everything but the parking lots?
Does it cover everything? No, sir. It does not cover shipping and receiving. It does not cover common areas. It does not cover portions within the Deep Point terminal.
In the building itself? Some of those were devoted to real estate sales or other purposes.
At that time they were, but some of them were also considered common area that could be used by anyone other than transportation.
And the shipping and receiving, is that over where the connection with the barge operation?
Yes, sir.
You testified in the sub 21 docket last fall, didn't you?
Yes, sir, I did.
The ferry operation was characterized in that docket as operating at a loss. Do you recall that testimony?
I do.
And is looking now at your testimony, your original testimony, page 3. Do you have your testimony?
No, sir, I don't.
Perhaps your counsel can provide it. For how many years has the ferry, to your knowledge, operated at a loss?
To my knowledge, I know that it's operated at a loss for the last 21 years.
And how many of those years since the 2010 rate case would it have not operated at a loss if the imputed dollars from the parking operation had been included in the financial statement?
I actually can't answer that for you because in the most recent financials, those losses have been substantially higher in past years. As activity for the ferry increased, those losses would have gone down. But that's probably not, never mind.
you state on page 3, I'm looking at page 3, line 7, that the ferry and the tram services have been financially stable, and your answer is yes. And yet you testify that you just told me that they operated at a loss for the last 21 years.
I must not have the same, we're talking about page 3, line 7.
Page 3 of your direct testimony, not your amended direct.
Amended, oh, I have amended.
Oh, okay. I gave her the amended direct. I'm sorry. I'm sorry, I don't have that with me, Mr. Higgins.
May I approach? May I approach?
Yes.
Subject to check, but that's page 3. Now that I have it with me.
So just make sure the record's clear. So you were asking her amended direct or the original direct?
It's the original direct. If I
Thank
said
you.
amended, I've fallen victim to what's making us up here. Would you read that question for me, please?
Yes, sir. Have the ferry and tram services been financially stable?
And your answer?
It is yes.
Okay. And that's your answer, even though it's operated at a loss, you consider for the last 21 years?
Yes, sir.
And was the ferry service effectively a loss leader subsidized by Limited in order to facilitate its development of the island?
No, sir, I don't believe that. And we attempted in the rate case to correct that subsidy, but we were not successful doing so in that 2010 rate case or 29 rate case.
So because you were not successful, Limited has continued to subsidize the ferry operation. Is that correct?
Yes, sir.
And the ferry operation is,
Ms. Mayfield and Mr. Higgins, if y'all could both,
Look your way.
yeah,
at
or
least talking.
get closer to the microphones, please.
I'm sorry. Oh,
did the last exchange come through?
sorry. Could you repeat the question, please?
I'll move on. Actually, I don't have any further questions for you, Ms. Mayfield. Thank you.
Public staff?
Thank you. Hey, Ms. Mayfield. Just want to confirm several quick things if I could. We've been told in discovery, and I think you indicated just now that the 19 million so-called loan will be written off at closing. Just want to reconfirm, no ifs and or buts. That will not be.
That is correct. No ifs or buts.
Second, imputation of parking revenue. If the appeal by the applicants results in the parking not being regulated for some reason, is it your understanding that the new owners intend to continue that imputation?
It's my understanding the new owners have agreed to continue the imputation to the extent that it was imputed earlier.
And your testimony indicates that y'all did due diligence on Sharpview and their management team to ensure financial viability and stability. Is that still the case?
Yes, sir.
And did you find, and your findings on that are still the case that they are financially stable?
Yes, sir.
And just final question relates to the so-called transition agreement or other agreements, maybe a shared service agreement, et cetera. What is your understanding about any impact that those agreements would have on ratepayers?
The transition agreement would be related solely to the transition of Limited to transportation. It would not be been passed on to the ratepayer at that point.
Thank you.
Redirect.
Yes, thank you. Ms. Mayfield, just a few questions. Do you have Village Mayfield Direct Cross Exhibit 1 in front of you?
Village Mayfield Direct Cross Exhibit 1.
That's,
I don't think, oh, yes, I do. Yes, okay.
Mr. Tratham asked you a number of questions about this document, well, specifically focused on the land basis parking lots of $325,000 or so, right?
Mhm, yes.
Can you tell us what time period the information on this sheet covers?
I can. This was developed from the initial purchase price from April of 1996. And most of the transactions fall through 96. And then there was some development work done in 09, a minor amount of deep point subdivision work done in 18, and then the survey where we divided the campus for this transaction or to prepare actually for the authority in 20.
So when you talk about the land basis parking lots, where was the terminal at the point that this,
96.
In 96, the terminal did not exist.
okay. Where was the property zoned for commercial operations in 1996?
I would assume so, but I don't know that. I wasn't here in 96 and I'm not sure,
Fair enough. To your knowledge, were there any environmental permits in 1996?
not to my knowledge.
All right. And to your knowledge, were there any improvements on the land in 1996?
I don't believe in 1996 there were.
So it was just the raw land that was purchased, is that
Mhm.
right? Okay.
Oh, I'm sorry, yes.
Let's see. Mr. Tratham asked you a number of questions about management functions. Do you remember that?
I do.
Has it been determined yet which management or accounting functions will eventually be performed by Sharpview after closing?
Currently, I can tell you what accounting functions are performed now, and they will be absorbed into Sharpview. But there is fixed asset work that we do, there's general ledger work, financial statements, there's, in some cases, billing, cash receipts, cash disbursements, accounts payable.
Okay. But that will be done by Sharpview going forward. All right.
Subsequent to the transition agreement, it won't be the very next day.
Okay. Mr. Higgins asked you some questions about the rent that transportation has recorded on its books. So that covers the rent of properties that were determined to be used by transportation in the last rate case, is that right?
Correct.
And so that was approved by the commission at that time,
Mhm.
correct?
That's true, yes.
All right. And then you were asked some questions about the capital budget. Is that a 1 year and a 2 year budget?
It's a one-year budget.
Okay, so that's not a long-term budget.
Not, well, we also have, we actually have three capital budgets. We have R&M capital, we have FF&E capital, and we have what we call development capital. And the R&M capital typically can be a 2-year process.
Okay,
And it's determined which one is most urgent for this year and what items are we putting on the radar for the next year.
nothing further at this time.
Commission questions? Chair Mitchell.
Good afternoon, Ms. Mayfield.
Good afternoon.
Just one question for clarification. You indicated the new owner, in response to Mr. Creech, the new owner intends to continue the imputation of parking revenues to the extent that it was that those revenues had been imputed earlier. Just explain what you meant by that response.
It's my understanding, and I hope I don't have this wrong, Mr. Paul can probably clarify this. It was my understanding that Mr. Roberts has agreed, and I don't know the time period, that he would allow the imputation of parking to remain.
Okay, and so what did you mean that to the extent they were imputed earlier?
In the initial, or not the initial, in our 29 rate case, to settle the rate case, when we We had originally asked for a $28 ticket. We were approved to get a $23 ticket. We then had to make adjustments to have the income statement turn out to be the 8.33% return. When we did that, we first took dollars out of expenses, and then dollars were imputed from parking revenue. And in the very end, there was a amount of, I think, $147 that was added as intervenor settlement to settle the rate case.
Okay. All right. So, but your understanding is that parking revenues annually have been imputed to.
Not on an annual basis. If we were looking at another rate case, that they would be considered in that initially. But I'm not sure, I should ask for clarification on that, David. I don't know.
Okay. Well, I'll ask Mr. Paul
Okay.
that question when he's back up on rebuttal. Okay. Thanks, Ms. Mayfield.
Commissioner Klopfelter.
Ms. Mayfield, one very, very quick thing for you. Mr. Trathan was asking you questions about the Exhibit A1 to the application. Do you still have that there in front of you?
Yes, I do.
Yeah, and he was asking you on page 4, he was asking you about the operating expense item titled management fees.
Yes, sir.
Well, something else caught my eye on that page. Since he was asking about it, I was looking at the page, and I'm just curious. It just really satisfied my curiosity. Up under the revenue item, there's a line titled Transportation Revenues / dash affiliates. What does that item represent?
The auditors choose to put the intercompany transactions between limited and transportation in that line item.
What would those be? Would those be like the maintenance expense on the barge?
Permanently, those are ferry tickets for employees or for the employees of limited, because they're related parties,
Okay.
they're reported that way.
Would that include, thank you, I understand what you just said. Would that item also include, for example, charges for maintenance work performed by transportation on the barge?
No, sir,
Would not.
No, sir, there's a credit taken against the management fee calculation for the work done on the barge and tug.
Thank you very much. Helps me
Okay.
understand the document better. Appreciate it.
So following up on Chair Mitchell's question about the imputation of the $523,000, is that, let's assume it is an annual contribution, is that in the transportation revenues, in that 6.7 million?
No, the books that are completed here are GAAP audits,
Mhm.
generally accepted accounting principles, and those imputations are not here.
Okay, and you're familiar with docket A-41 sub 7A?
Yes.
And you probably make those filings for the
I
company?
do.
And so in February of each year, you make a filing and it shows the full year prior
In the annual report.
in the annual report, correct?
I review that, yes.
Okay, and so would you agree, subject to check, that for year 2022, the ferry's net loss was 1.3 million
Yes,
approximately, and in 2021, the net loss was 400,000
right.
approximately, and then in 2020, the net loss was around 985,000.
I'm not sure about 2020, but I believe so.
Subject to check.
Yes.
In 2018, the net loss was 942,000. And then we'll do two more. 2017, 368,000 net loss
Subject to check.
approximately. And then 2016, approximately $500,000 net loss.
Correct.
Okay. Those are my only questions.
Okay, thank you.
Questions on commission or what? Yes, Commissioner McKissick.
Let me ask you this. There was exhibit that was introduced earlier when Mr. Cole was up for cross-examination. It was called Village Direct Poll Cross Exhibit number 2. I'm just curious as to if you're familiar with that particular document.
I am not sure I remember which document that was, Mr. McKissick.
Ms. Mayfield, we'll get someone, your attorney, to hand it to you.
Are you familiar with the figures reflected in this document?
Yes, sir.
You are, okay. Now, and of course, it's showing, from what I understand, this is about income and expenses for the ferry and the barge. Would that be correct? But not including the parking.
Right. No, well, it does say parking.
It does include the parking. I think
It's
earlier they indicated it would also. Well, it does have income from parking. Now, let me ask you this. So these figures also appear to be pretty accurate to your recollections?
Yes, sir.
And when it comes to, I guess, the bottom line in terms of net income in 2020, it looks like it's $1,036,453. Is that correct?
I believe.
That's your column all the way to the far right.
Right, but these were the P&Ls that were used in the forecasting, I believe, for 2020 and budgeted 2021. Oh, well, I'm sorry, I misspoke because these are all three. These are transportation, parking, and barge. Yes, these are
Transportation,
correct.
parking.
Yes,
So this would be an accurate reflection for 2020 where you end up with, it looks as if total revenue that year was 10,403,294,000, and total expenses were $7,091,900, and then there were other expenses of $2,098,369.
correct.
Is that correct?
Yes, sir.
Now, it does indicate under notes, if you go to notes, you see note E says Hurricane Florence, September 2018 had a significant impact on tug and freight barge operations. Looks like that's from fourth quarter of 2018 to second quarter of 2019.
Correct.
Would you happen to know how much difference that might have made?
Not off the top of my head, Mr. McKissick.
Okay.
But I do know we did have substantial impact from the hurricane because we had to significantly, for a 30-day period, we reduced service to the island altogether.
Altogether?
Mhm.
There would have been a substantial impact.
Yes, sir.
But
And may I clarify one thing real
Sure.
quick here? This is not one of Bald Head Island's documents. This is a Sharpview document, so
Right.
this is not something I prepared, just so that I'm clear on that.
Sure, I
Okay.
appreciate that clarification. Now, let me also ask you about one other item here. Under notes, you see item G says Bullhead Island Transportation was the beneficiary of a $496,300 PPP loan from the SBA. They received on May 4th, 2020. That was completely forgiven December 9th, 2020. Now, is that reflected in the totals under other revenue, which you're showing for 2020, where it has the 510,000?
Yes, sir,
And is that why that number is higher for that year?
it is.
Now, are you aware of any other loans that have been forgiven during the time frame shown on this document?
No, sir.
Not aware of any. But I think you indicated in responding to public staff attorney that it's likely to be 19 million in loans forgiven as a part of this transaction.
Correct.
Is that correct?
Yes, sir.
But those would be the only other debt that you're familiar with that would likely be canceled or forgiven.
Correct. That's the sole debt on the balance sheet.
Thank you. I don't have any further questions.
Ms. Mayfield, I just have a couple of more going back to those quarterly financial reports. And you might not be the right person. You just let me know if you are not. But, you know, we've heard testimony about the on-time departure percentage rates. And if you look at those year-end reports, it looks like it's subject to check that in 2016, the on-time percentage was 89%. In 2017, it was 85%. 2018, 87%. 2019, 86%. 2020, 84%. And then in 2021, it drops to 66%. And then in 2022, it's at 68%. And so my question to you, first of all, does that sound accurate to you?
It does.
And so just in your opinion, why has it taken a deep dive in 2021 and 2022?
And let me say that I am not the best person to answer this question.
Okay, who do I need to ask?
Mr. Byron Stewart.
Okay.
Or Mr. Paul, either one.
Okay.
And Mr. Stewart will be testifying later in this hearing.
Okay. I will save that for Mr. Stewart unless you want to offer up your opinion.
I'm happy to give you my opinion, but Mr. Stewart is going to be the best person to have the actual technical response to that.
Okay.
I think there are several impactful situations with that. One is the amount of baggage and the baggage that we started carrying and handling. And as the ridership increased, so did baggage. The other problem, and we went to the Corps of Engineers to ask that they station their dredge work elsewhere because it's a no-wake zone through as they set up in the river, which significantly slows down our transport. The Corps indicated they were not able to do that. So part of it is the traffic as well, and the requirements on the ferries for no wake.
Thank you for that answer, Ms. Mayfield. Questions on commission questions?
Yes. Ms. Mayfield, Commissioner McKissick asked you a few questions with regards to the consolidated historical income statement. Do you still have that?
Yes, sir, I do.
Two quick questions flowing from that. Right above net income, there's a figure for other expense. Do you happen to know what that is?
That would be any of the operating expenses, not specifically salaries and wages. It would be supplies, fuel, office expense, training and education, uniforms. There's a substantial list of expenses in that line.
Okay. And with respect to footnote C, and I understand that this is Sharpview document, the note C states that the facilities lease expense of $1.25 million, and all the underlying real estate with the lease is being purchased. So that expense will be extinguished at closing. Do you read that to say that the plan as of this statement was that there would not be a lease because with respect to the real estate, because all of the ownership would be consolidated in Sharpview?
I'm just going to object to asking the witness to speculate as to what the author of that comment meant.
Mr. Traven?
Asking her what our understanding of this note is in the financial statement.
Just answer as best you can. If you cannot speculate, you cannot speculate, but answer to what you know.
I believe this footnote is related indeed to the lease that currently exists between limited and transportation.
Okay.
Does that?
That's fine. That's fine. That's all I have. Thank you.
Ms. Mayfield, with regard to Commissioner Duffley's question, where she read you some results of annual reports indicating operating losses over a period of years, you can call that.
Yes.
And do those reports, I don't have them with me, do those reports reflect the imputation of the $523,000 imputation from parking revenues?
No, sir. No, sir.
So where in the financials is the $523,000 imputation reflected?
On the monthly financials and on the annual financials, the parking imputation is not reflected.
Is it reflected anywhere?
No, sir. Other than in the rate case settlement, because it was an amount chosen for the settlement. But you can't hear me, can you? Sorry. Other than in the rate case settlement, because it is an amount that was part of just the settlement.
Does that mean that the $523,000 imputation has not been imputed each and every year since the rate case?
Into the final financials, GAAP audit, it has not been.
Has it been imputed anywhere?
No, sir.
Thank you.
Ms. Mayfield, just have one follow-up question. You were asked about Hurricane Florence and the impact on net income, I believe. And I just wanted, and the SBA, the PPA loan, was there also business interruption insurance proceeds that were received, and I think around 500,000? Does that sound?
There was business interruption insurance that was received. Off the top of my head, I don't remember right now what it was. I didn't think it was as high as 500. But
Okay, okay, thank you.
Redirect.
Nothing further.
Okay, motions?
Yes, I would ask that the village cross-examination exhibit 1 be entered into evidence.
Without objection, your motion is approved. Ms. Mayfield, you're excused. Thank you.
should I just leave these right here?
You can leave those there.
Ms. Mayfield, can I get my
Yes.
page of testimony?
So as by agreement with the parties, Mr. Roberts is actually teaching at the Duke University Sanford School of Public Policy. And it has a weekly obligation to teach as an adjunct professor at the Sanford School. So he was not available. He would normally be our next witness. He would be available to be called tomorrow, and that was and so if the commission wanted to continue with the hearing, what we had agreed to was that they would continue now with the next witness of the village.
Okay, let's go off the record for 5 minutes. Colleagues, let's keep the case intact. So we're going to recess for the day, and we'll come back on the record tomorrow at 9:30 a.m. and we'll have Mr. Roberts at 9:30 tomorrow morning.
Okay. Fine.
Go off the record.